Do I have a case if I slip on olive oil in the Whole Foods on Alton Road in South Beach, but there's a yellow cone 6 feet away and I was staring at my phone?
You might have a case. Here's why. It depends on whether or not the store knew about the olive oil on the floor and the proximity of that cone and the other steps they took to warn customers. However, that bit about you looking at your phone and being distracted, that would just go toward your contribution of your own negligence and potentially reduce your damages. New law in Florida dictates if you're 51% or more at fault, you're not going to recover anything anymore. So that's a tricky one, probably a riskier case, but you still might have a case.
What about if I face plant on a wet tile floor by the food court at Sawgrass Mall? There's no warning sign, and my lawyer sent a footage preservation letter within 48 hours. The notice and evidence is strong.
Well, so says you. I still think you might have an even stronger case with this one. What it really hinges on is how long the floor was wet, what caused it to be wet, and whether or not the store had an opportunity to know about that. Was the water discolored? Is there any other evidence we have to show how long the water had been sitting for? Was the wet floor within the eye line of an employee? Notice is a huge element to these premise type cases, and that's what you're going to have to beat in order to defeat summary judgment, where they get to take a full home run swing at your case before you even get to trial. So I still think you probably have a case with that one. It's going to depend on that water, how long it was there, whether they knew, and elements that go toward whether or not they should have known if they didn't have actual notice.